let's remember how we got here. We got here because this defendant in October picked up a new aggravated stalking where he told somebody that he could enjoy his Colombian bow tie, bitch.
State of Nevada versus Bellisario, C354165. 23. Thank you.
All right. This is defensive. Okay, go ahead and check in. Sorry, guys. Appearances?
Colleen Baharav for the state.
Mace Yampolsky with Mr. Bellisario is present.
Thank you. So defendant's motion to modify pretrial release conditions to permit defendant to discontinue electronic monitoring and wearing of the ankle bracelet. I know we also had a motion to withdraw as counsel. Is that still your position?
Yeah.
Do you want to hear that first?
I think that's already set for the.
Oh yeah, February 9th.
Yeah, you said it's the day after the other court.
Right, I forgot about this one. Okay.
Your Honor, Mr. Bellisario performed his address here.
Okay.
So basically in this, I mean, the reason why I prefer to address the court is it's been such a long time I've been trying to have my attorneys file this motion. I go back to Mr. Grasha before this, Mr. Gooden before that. They'll come up with excuses every time. Mr. Yampolsky had the information to file this since November, kept making excuses, and then finally I was able to call him on it with proof in January, and they finally, he didn't actually prepare it, his partner prepared it. So we got something in front of him, which I'm happy to have something in front of you. Now, when you look at the state's opposition, my first problem with it would be, under the local rules, I believe after filing a motion in the criminal court, they have 7 days to respond.
10.
Alright, we still took 15, right? And then left me 2 business days to prepare before this hearing, which the entire case is moved about hindering my due process rights, so I have no chance to be heard. So I would say they shouldn't even have the opportunity to have their opposition be heard. My motion should be deemed accepted.
Anything else?
I have tons of extra stuff, so I don't know how far you want me to go into it. Let's see. All right. So yeah, I mean, if we're going through the facts of this, the first part that brought us here was she goes through how it was put on house arrest the first time in 2020. She omits how that actually happened. It goes back into November of 2020, in which we had a return hearing on a DUI, which they were arguing for remand. I didn't get remanded. On that same day, the district attorney's office filed to have me prosecuted for a case involving a TPO that was allegedly violated. They said I was arrested and came to court on January 25th for that. So what happened was, on January 25th, which was the first day for a new judge in family court, they brought me here, so I missed my family court hearing. The state filed 1 charge, which was for violation of TPO. We said, hey, we dismissed or dissolved this TPO a year ago. And we went to court for it already, went back to court on it. The TPO judge found it was already agreed to stipulated to be dissolved and closed the case. My ex-wife then continued to say she had a TPO against me, filed multiple police reports regarding the same thing. They arrested me. So on the 25th, they had that charge. The 26th, they came back and filed a different TPO violation. We also showed that wasn't good. On the 27th, what they did was they combined an old case and a new case. Instead of doing what they're supposed to do and put it back to the old case, they put it into the new case. So now the judge in that, Judge Graham, put new bail instead of having me on when I was already there. So once I had already had those charges dropped for the TPO violation, so I had less charges than when I got arrested. But but she somehow increased the bail, saying I was arrested, so I needed to be on house arrest, which we showed was false, and they agreed it was false. So I never should have been on house arrest in the first place. There's a lot of things in their motion that aren't correct. I don't know if you want to go through, highlight everything now. I guess I can wait until after she argues her point, if you can let her argue her point. It seems like she's playing a game of telephone with herself where the facts change every time there's a new filing. To go back to the process issue, I'll say the other cases before you. The state filed a motion to appoint Mace as my counsel case. I was unrepresented, unable to defend myself. They filed a 7-page motion full of allegations, some of which were up for the first time, and somehow that was allowed to go. The only thing that came of that was Mace sent me an email saying he wanted $10,000. I told him. He said my reputation for you would be diminished because I didn't hire his counsel. I still refuse. That's what we are. You put it in the email. I have documents showing the whole chain of what I said before about the TPO being dismissed, filed, all that. There's a transcript here that shows District Attorney Lamont lying before that court in front of Judge Graham, saying that she couldn't possibly look any of that up, even though she had 5 months prior to look it up to see that it was dismissed. Somehow my public defender looked it up that day, even though she was claiming there was no possible way to do it.
Well, if it puts your mind at ease, the court has no concerns about the fact that you chose to have a public defender in your other case, and your credibility has not been injured on that respect.
I just was one of those things where I had no opportunity.
I just don't want you to worry about that. I can confirm there's no issue there.
The other thing would be, those are my kids, right? That one there, it's her birthday tomorrow. I haven't seen them in 475 days. You might ask why. That's because while they've been trying this together with my family court case, family court issued an order. They gave me custodial rights, but said you can't have those until you finish this case.
Okay, understood. Anything else? I mean, you are going to have a chance to rebut.
I have plenty of information. I guess I'll see what they say.
Okay, thank you. Stay.
As this court's well aware, the state of Nevada does not prosecute family court cases unless it relates to TPOs. So the fact of the matter is that his divorce case and other custody proceedings have nothing to do with any of the prosecutors in our office. He's free to make whatever allegations he wants against Ms. Lamanna, but let me remind this court that while that was all going on, this defendant was then accused of sending threatening letters to Ms. Lamanna wherein he threatened her child. So that's one of the cases that he's facing. I understand he disagrees with the facts of these cases, but the fact of the matter is, you're right. I didn't include the 5 other cases I saw in Justice Court that I should have included for this court in terms of his prior criminal history. But what I did include are the 3 cases that are currently pending in District Court. I also included the case in Justice Court regarding Ms. Lamanna. In terms of he should never have been on house arrest in the first place, let's remember how we got here. We got here because this defendant in October picked up a new aggravated stalking where he told somebody that he could enjoy his Colombian bow tie, bitch. So if we're talking about somebody behaving in a manner wherein house arrest is necessary, it's this defendant. This court disagreed with the state. This court told the state, despite the fact that we asked to remand him with no bail because he continued to engage in the same criminal conduct, that you believe that the community could be protected if he remained on house arrest with alcohol monitoring. To date, I haven't received any new cases. So clearly, that's working. What wasn't working were the lower levels of monitoring, the bail that was previously set into place. So if we're going to readdress this defendant's custody status, which we addressed in the motions before this court in October of 2021, the state again wants to be heard about its choice or recommendation that this defendant be remanded. The court's already disagreed with us. The court's already imposed these particular requirements on this defendant. We ask that they remain up to and including whenever this court decides some nebulous motion to withdraw his guilty plea that he's attempting to do in all three of these cases. If at that point the status of the cases changes, if the original charges are somehow reinstated about his custody status, but right now nothing's changed. The only thing that's changed is that time keeps going on, the defendant keeps forcing continuances, he keeps getting new lawyers. In addition, despite the fact that he has a new lawyer who's trying to withdraw, this defendant is still trying to contact former lawyers and in fact going to their offices. Unacceptable. House arrest means house arrest. I understand that you can claim some legal reason to go to these former lawyers' offices, but that's not valid. You have an attorney. And of course, if this court allows, we'll contact house arrest and indicate which attorney he currently has, so the rest of those officers are off limits. This defendant had issues. We filed our motion to remand him. The fact of the matter, whatever his family court decided about the custody of his children, is completely irrelevant to the criminal case. You want to address that with family court? Go ahead. But don't impute to the state some sort of issue with your family court case that we cannot participate in because it has nothing to do with our office. In addition, Your Honor, I really do think that you were right. I mean, we have to admit it. You impose conditions less restrictive than the state asked for, and they're working. We're asking that the court keep these conditions in place. In addition, you can move up whatever hearings you want to move up so that we can get this case moving, because ultimately, at sentencing, this issue is going to be moot. We'll either put him on probation, you'll put him in prison, and we'll be done either way.
Thank you. Anything else?
Yeah, so as far as them saying they have no issue with family court, they can't decide any of that. It was the alleged victim in this case that went to family court and said, I don't want him to have custody until those cases are dismissed. Right? They have control over their alleged victim. They're supposed to monitor what they say. It's in your ethical rules, right? So we also go with, I asked her to be quiet when I'm talking.
I'm not speaking.
So,
Thank you.
Even motions, even your body language.
Everyone, take a breath, including the state. Let's take a breath. Okay, go ahead, Mr. Bellisario.
All right. As far as, bail conditions and all that, she's claiming there's no different circumstances. The circumstances are put there in the letter by my doctor, who stated, I saw treatment, we did all that. She's saying no other lesser conditions which, can solve this. I would say that constitutionally you're supposed to do what is the least restrictive condition to ensure safety of the public and ensure that I come back to court. Come to every hearing, nothing's happened. It's been 13 months. Nothing in this case. The issue in this case, they're saying, is text messages. I've had a phone the entire time. It's not stopping text messages. I agree. In the letter of my doctor, I said, if you want to keep me on the alcohol monitoring, keep me on the alcohol monitoring. That's not an issue. She's claiming I shouldn't be able to go see prior counsel. Prior counsel still has things to do with my case. That's what the high-level impacts of my case was. I had a harder time preparing a defense. My attorneys aren't doing anything. In fact, I asked him to prepare things for today. He refused. So I don't know what I'm supposed to do with that. I'm basically doing my own case. By putting me on a high level or even just mid, it prevents me from having familiar support and from defending my cases. And as far as the family court case goes, I would say putting my right to my constitutional right of parentage versus my constitutional right to the Sixth Amendment fair trial is unconstitutional. So every day these cases are open is violating my constitutional rights because family court did it, and district judges can't overrule district judges. So as long as that order is in place, every day I'm here is violating my right to a fair trial.
Thank you. All right. I remember the hearing very well where these current electronic monitoring and SCRAM requirements were placed on you. Please recall the nature of the text messages that you were sending, and it was this court's perception based on the evidence in front of it that alcohol was involved, and that as long as you stay sober and under strict monitoring, you won't be a danger to the community, which has vetted out to be true. Also, please keep in mind that because you have pled, although you're attempting to withdraw that plea, you've lost the presumption of innocence. It's this court's determination that there has not been any change in circumstances. I appreciate your doctor's letter, and I'm glad you're getting treatment. And I believe that is one of the reasons that we have gone these months without an additional problem. And I think the risk of changing any of that is way too high, again, especially with the circumstance that you are no longer entitled to the benefit of the presumption of innocence. So with no change in circumstances and the fact that the community has been safe, including your ex-wife and any prosecutors that you were threatening at the time. The court is not inclined, either legally or with regard to the safety of the community, to change, so the motion is denied. Thank you.
So you're telling me that
Mhm.
you're telling me that mental health treatment was
Not under the totality of the circumstances in this case. That is the minimum that I would have expected you to continue or to take part in under the circumstances. I really would like you during your therapy to sit down and think about the things that you did and the things that you said, and this is in writing, so I don't think there's a lot of question as to what was done at the time. So the fact that you're receiving treatment is, as the minimum, continuation of what you need to do in order to stay on the status that you're on, not to get off of it.
right, but that wasn't actually stated.
It wasn't required, okay, but you did it and it was a good idea, and I think it's a part of the reason why you haven't gotten in any trouble. And honestly, I'm trying to help you keep from tripping yourself up.
Right, and can I ask the court for just to file?
You can file an motion to change custody at any time under the rules. So we'll see you guys on the 9th. Thank you. State, would you mind drafting a quick order?
I will.